Hello, everyone. We're glad that you can join us. Welcome to today's presentation, Streamline the Contract Process when Juggling Multiple Projects, Master Agreements and Work Orders for Contractors. Just a foreword before we get into the substance of our topic. This presentation is protected by copyright laws. Therefore, no portion of it should be reproduced without written permission. And as a general disclaimer, no information shared here today should be construed as legal advice, nor is any attorney-client relationship established. My name is Colleen Telling. I am manager and counsel of the AIA Contract Documents Program. I work with our documents committee to create and revise AIA contract documents and also write associated collateral. Prior to this role, I practiced municipal, business, contract, and real estate law at a private law firm in Cleveland, Ohio. Before my legal career, I worked in construction management and contract administration for Jacobs Engineering. There, I was involved in heavy civil and infrastructure projects for public clients in Virginia. I also spent time working in project development for a residential design-build contractor in Ohio. Besides my law degree, I also have a degree in electrical engineering, as well as in construction management and architectural technology. Our agenda for this session is as follows. We're going to look at an overview of owner-contractor master agreements and work orders, followed by core terms and conditions in a master agreement. We'll then look at contract specifics in a work order and finish our discussion with contractor, subcontractor, master agreements, and work orders. So as I mentioned, we'll begin with an overview of an owner-contractor master agreement and work order. So why would a contractor want to use a master agreement instead of a traditional owner-contractor agreement? Well, the first and most important reason is for repeat business performing the same type of work on multiple projects. So as an example, you're a contractor who specializes in light commercial construction and has offices in multiple cities. McDonald's wants you to build 20 new restaurants. Executing an owner-contractor master agreement is ideal because you can execute a lengthy agreement one time to standardize several core terms and execute short work orders that capture specific detail about the build for each particular location. At the next tier, you as a contractor can execute a contractor-subcontractor master agreement with a sub who will install all mechanicals. That master agreement will also be executed once to memorialize terms and conditions that apply to each work order. A second reason to use a master agreement is to save time drafting and negotiating core contract terms and conditions by addressing them once. On the next slide, we'll look at what some of those terms and conditions are. A third reason to use a master agreement is because it applies to all work orders performed under the master agreement. So all details about the scope of work are contained in a short work order, and this format allows multiple scopes of work to be issued quickly. A work order is not executed until the parties sign a master agreement. And lastly, a contract is formed when both a master agreement and task order are executed. So core contract terms and conditions in a master agreement are general terms that describe how the master agreement work order arrangement works, identifying who the owner and contractors' representatives are for anything related to the master agreement, issuing payment, procedures for addressing and resolving claims and disputes, general responsibilities of the parties, allocating insurance coverage between the parties, and termination of the agreement. In subsequent slides, I'll discuss each of these in turn. So we've touched on the makeup of a master agreement. Now let's look at what a scope of work contains. Topics that will vary by project are not considered standard terms and conditions for a master agreement, so instead they're found in a work order. These include dates of commencement and substantial completion for the work, identifying the contract sum, which is to be identified as either a stipulated sum or cost of the work, naming representatives of each party specific to the work order, terms that differ from or are in addition to those in the master agreement, such as payment, insurance, and bonds. So I'll be referring to AIA's master agreement and work order as an example of standard language that's found in this contract arrangement. AIA's owner-contractor and contractor-subcontractor master agreements are the A series listed here. Work orders are used when a contractor or subcontractor performs work, and service orders are used when an architect or consultant performs services, but we're only concerned with work orders here. When I discuss the master agreement and work order, I'll be speaking in terms of the owner-contractor relationship, but know that the information is equally applicable to the contractor-subcontractor relationship. So with that introduction, let's look at the substance of the master agreement's core terms and conditions. As I mentioned, core terms and conditions describe how the master agreement work order combination operates. One of those terms establishes that the master agreement is effective for all work orders for 1 year after the date indicated on the master agreement. That may be the date that an original oral agreement was reached, the date the master agreement was originally submitted to the owner, or the date of actual execution. After the 1 year mark, the master agreement renews annually unless one party notifies the other that it does not wish to renew. When the parties don't renew the master agreement, its terms still apply to all work orders executed under the master agreement until the work orders are completed or terminated. Conflicts between the terms and conditions of the master agreement and work order are resolved in favor of the work order. That's because the lower level, more specific agreement is meant to control. And lastly, the master agreement provides that the work order is to be governed by the law of the place where the project is located. In the example of a contractor building restaurants for McDonald's, those will be in locations throughout the country, so it's appropriate and fair that the law of the locations for those various projects should govern. Naming representatives of the owner and contractor for the master agreement is part of the core terms and conditions. One of the first sections of the master contains a provision with space to insert the name, title, and contact information for the individual who is authorized to act on the owner's behalf and also the contractor's behalf with respect to the master agreement. The master establishes the overall procedures for the contractor to be paid. The first step in this process is for the contractor to develop a schedule of values, breaking out portions of the work, and submit it to the architect at the start of the job. The schedule of values is necessary on a stipulated sum project or cost of the work with a guaranteed maximum price, because in both situations, the cost is not to exceed a fixed price. So contrast that with a cost of the work project without a guaranteed maximum price that has a control estimate. In that case, a traditional schedule of values would not be submitted because costs are initially estimated and then reimbursed. Payment terms in the master agreement provide that after the contractor has completed a portion of the work, it can submit a pay-app to the architect for approval along with lien waivers. The payment terms elaborate on details about timeframes. For example, the contractor's pay is to cover 1 calendar month, and the number of days in which the owner has to pay the contractor, which is a fill-in point for the parties to agree on. Lien waivers are an acknowledgement that all title to the work covered under the current pay-app passes to the owner at the time of payment, and previous payments received have been dispersed to other trades and suppliers. There's also an area to describe the amount of retainage, if any, that the owner will withhold from the contractor's pay-app. The provision is open-ended, so the parties can agree to a percentage or set amount of money that will be withheld. Once the owner and contractor accept the certificate of substantial completion, the master agreement requires the owner to pay out retainage. The master permits final payment when the contractor provides a full release of liens. For their method of binding dispute resolution, the master agreement requires the parties to check a box for arbitration, litigation, or other method. And other types of dispute resolution might include a dispute resolution board or a mini trial. If nothing is selected, then claims are resolved in court. When there's a dispute, AIA's master agreement requires the parties to first pursue mediation, which is non-binding but is mandatory under the agreement. The dispute resolution section outlines procedures for notifying the other party of a request for mediation, as well as a demand for arbitration. As part of their agreement, both parties agreed to waive claims against each other for consequential damages arising out of or relating to the master agreement. On the screen is an excerpt of that contractual language. So you can see from the owner's side, the owner waives damages it incurs for rental expenses, loss of use, lost profit, loss of financing, and lost productivity. There's a reciprocal version on the contractor side, where the contractor waives damages that it incurs for principal office expenses, and also, like the owner, loss of financing and lost profit. There are a number of rights that each party has. as well as responsibilities that each agrees to in the master agreement. We'll look at this from the context of the owner and contractor. Beginning with the owner, upon the contractor's request, before starting construction, the owner must show reasonable evidence that it has the financial ability to pay the contractor. Without that evidence, the contractor does not have to start the work. The owner is also required to provide a survey and other necessary information about the site. The right the owner has is the right to stop the work if the contractor fails to correct the work or repeatedly fails to carry out the work. If the owner stops the work, the master agreement provides the contractor with a 10-day window in which to correct the work. If the work is not corrected after that time, the owner can carry out the work with its own forces. Responsibilities of the contractor. These are basic, but they are worth noting. And as you can tell by glancing at the list, there are a lot of responsibilities that rest with the contractor due to the risks inherently involved in constructing a project. The contractor is to review the contract documents and field conditions. So this means visiting the site, becoming familiar with the conditions, comparing field observations to the contract documents, and taking field measurements. When supervising and directing the work, the contractor is to determine the best means, methods, sequences, and coordination. Next, warrant that materials and equipment are new, of good quality, free from defects, and otherwise conform to the contract documents. Obtain and pay for the building permit and any other permits. Under the master agreement, the contractor is also required to provide its construction schedule. This would occur after executing a work order when the full scope of work is identified. Of course, throughout the duration of the project, the contractor is responsible for updating the schedule as appropriate. Gather, review, and submit shop drawings, product data, and samples to the architects for review. By submitting these items, the contractor represents that they comply with the contract documents. Maintain a safe site relative to people, the work, and property adjacent to the construction area. Hazardous materials. If any are encountered during construction, notify the architect and owner and handle them appropriately. Correct non-conforming work during construction and the 1-year warranty period. Another topic that the master agreement specifies is insurance. The contractor is to maintain insurance until the period for correction of the work expires, so generally for 1 year. The owner's obligation is to maintain its usual liability insurance. The contractor is required to carry commercial general liability, or CGL insurance, which covers damages due to bodily injury and physical damage to property. The corollary on the owner side is builder's risk insurance, which the owner is required to carry until substantial completion, at which time the policy converts to standard property insurance. Other types of insurance that the master agreement requires the contractor to carry are auto liability, workers' comp, which pays an employee's medical expenses and partial lost wages from work-related injuries and illnesses, and employer's liability insurance, which protects the employer if the company is blamed for an employee's injury or illness. In particular, it covers legal defense costs for cases of negligence. In many states, workers' comp policy includes employers' liability insurance, but in a handful of states, such as Ohio, employers' liability must be purchased separately. The termination provision in the master agreement considers 3 scenarios for terminating the agreement and establishes procedures to follow in each instance. The first considers termination in the event the contractor terminates for cause. This could happen if, for instance, the owner fails to pay the contractor within 30 days. Another instance is the owner terminating the contract for cause. The triggers for this could be a lack of skilled workers, the contractor's failure to pay subs, or disregarding laws. And lastly, the owner may terminate the contract for its convenience. In that case, the owner is responsible for paying for work executed, costs that the contractor incurs due to termination, such as costs to terminate its subcontracts, and any termination fee. So we've covered the types of core terms and conditions in a master agreement. Now let's look at the contract specifics in a work order, which is a much shorter list. The first contract specific to note is identifying the dates for starting the work and also for substantial completion. As shown on this slide, the work order contains checkboxes to determine when the work will commence. For substantial completion, the parties also select the date from a checkbox system, either specifying a number of calendar days from commencement or specifying completion by a specific date. The work order provides 3 options to stipulate the contract sum, those being a stipulated sum, cost of the work plus the contractor's fee with a guaranteed maximum price, and cost of the work plus the contractor's fee without a guaranteed maximum price. If any liquidated damages are to be assessed, they are also identified in this section. In the work order, naming the representatives of each party is a very short section, as you see here. These individuals are specific to the work order, so they may or may not be the same individuals named in the master agreement. In the work order, there is a fill in the blank that allows the parties to explain any payment terms that might differ from or are in addition to those in the master agreement. Examples could be the period covered by each pay-app or the date that each pay-app is due. On the retainage front, this might pertain to retainage amounts, items that are not subject to retainage, or terms for reduction. As to insurance, the parties can specify any insurance requirements that differ from those in the master, like the coverage type and limit. One type of insurance that might be in addition to the basics specified in the master agreement is professional liability insurance, or PLI. This is used when the contract requires the contractor to perform professional design services. Another type of insurance that might be in addition to those in the master is pollution liability, which would be needed when transporting, using, or releasing pollutants. For bonds, there are 2 types you're likely familiar with, payment and performance bonds. Payment bonds pay for labor, material, and equipment on the project when the contractor defaults on payment. Performance bonds pay when the contractor ceases to perform the work. By being in the work order, all of these provisions address project-specific requirements. All the terms and conditions that I described in the master agreement, as well as the contract specifics in a work order between an owner and contractor, exist in a master agreement and work order between a contractor and subcontractor. In this fourth and final part, we'll cover a few notable differences between the two types of contracting parties. Regarding conflicts, where a provision in the prime agreement is inconsistent with the subcontractor master agreement, the master governs. As between the subcontractor master agreement and a work order, the work order governs. This is consistent with the priority structure in the owner-contractor agreement. The prime contract is incorporated into the contractor sub-master agreement, so the terms and conditions that the owner and contractor agreed to flow down to the contractor and sub. For instance, as long as the responsible party performs its work per the design, it will receive timely payment. If not, the owner and contractor's remedies, such as stopping work or terminating the agreement, flow down to the contractor and sub respectively. When there's a claim or a dispute between the contractor and sub, the master provides two paths for resolving it. The first is that if the claim or dispute involves the higher tier, so the contractor and owner, the parties follow the dispute resolution method in the prime contract. On the other hand, if the dispute does not involve the contractor and owner, the parties proceed to mediation and thereafter binding dispute resolution. The insurance article contains a fill point for the type that the sub must carry. One point about the subcontractor master agreement is that it does not explicitly provide for liquidated damages. Instead, it refers to the prime contract for LDs. This master states that a subcontractor will only provide professional design services when the subcontract documents require it. When they do, the contractor provides the performance and design criteria from the prime contract. An important point about termination is that when the owner terminates the prime contract for convenience, by way of flow down, the sub is entitled to receive payment for work that it executed properly. Additionally, the payment and retainage provisions are modeled after those in the owner-contractor master agreement. An example would be the default pay-up period covering 1 calendar month. The subcontractor work order also contains checkboxes to set the date of commencement of the subcontractor's work, which may not necessarily coincide with the project's start date, and the date of substantial completion, which may also differ from the project's finish date. The subcontract sum is entered in the work order, as this will likely vary with each scope of work. The pay-up period may vary from the default in the master, so the payment and retainage section in the work order allows the contractor and sub to insert those variations. When a sub must provide insurance that's in addition to or different from the master, the types and limits are entered in the work order. Also, the penal sum of payment and performance bonds is to be provided in the work order. Finally, the work order requires designating authorized representatives who may be the same as those designated in the master. And that brings us to the conclusion of our program. If you'd like to learn more about our documents, I invite you to go to aiacontracts.org/learn. For questions about the content in our documents, you may reach out to the email and phone numbers shown, and also for our technical support line. Thank you so much for joining this presentation. I hope that it's been informative and provided insight into the makeup of master agreements and work orders that a contractor might use.